Hello, my name is Daniel Allerton. I will be on the affirmative side of this debate, and the issue that we are debating is the exclusionary rule. My claim is, courts should replace the exclusion of evidence in violation of the exclusionary rule with civil fines. Now, in this debate, you're going to be hearing a lot of legal terms, so I'm going to give you some definitions. The exclusionary rule relates heavily to the Fourth Amendment, and you'll be hearing a lot about it. In the Fourth Amendment, it says that basically it prohibits unlawful search and seizure, so you cannot be searched and have things like searched by police without a legal warrant or law that precedes that. In law, there's probable cause, which is part of determining whether this makes sense, whether there's probable cause. It's proof, and so that, and part of probable cause is it's very subjective and it's not very concrete. So there's a lot of error involved, which is part of our debate. Independent source rule is something I'm going to be talking about. It's a legal principle stating evidence obtained illegally will not be suppressed if found by a legal search later. And qualified immunity is one more definition that protects police and officials from civil lawsuits and lawsuits relating to misconduct. So my second claim is that one of the biggest issues with the exclusionary rule is that the holes in it, there are a lot of holes in the exclusionary rule that necessitate the need for a change, and that a change has to be flexible enough to cover said holes. One of the holes in the exclusionary rule that's very controversial is the good faith exception, which means evidence found by an illegal search is admissible, which means usable in court if the officer was acting in good faith, such as they were on a warrant that at the time was legal and true, that was later invalidated, or there was a mistake in, say, a police system and a warrant was not updated. Under good faith, whether it's a warrant or something such as a law, the officer is only fulfilling their responsibility to enforce the law, and so it's not really their own, it's not exactly a malicious intent fault. Some may claim that there's malicious intent, but because of it's called good faith because it's determined that they're just doing their job. This comes from a court case known as United States v. Leon, where, to quote the opinion of Justice White, in most cases, there's no such police illegality and nothing to deter. It is the responsibility of the magistrate, the judge, to determine whether the officer's allegation established the probable cause. And this has been very controversial because it goes over the Fourth Amendment, and it establishes a way to use evidence obtained illegally legally. There's another part of the exclusionary rule that relates to the Fourth Amendment called knock and announce. Knock and announce essentially is a legal rule mandating the police cannot simply break down a door with a warrant. They have to knock, which is why it's called knock and announce. Knock, announce they're there, and wait an arbitrary period of time before entering. And if this is broken, it is not exactly a full breaking of the Fourth Amendment, but it is still something illegal that's happened. So the evidence obtained is still legal because under warrant, but because it is illegal per se, this relates to my claim about civil fines. Another hole in the exclusionary rule that's been controversial as well is, as I mentioned, the independent source doctrine, which the evidence obtained illegally can be used if later obtained legally, which means that, say something is found illegally and they cannot use it in court, but they get a warrant later, they get a warrant legitimately, legally, that stays illegal, and they can use the evidence later. This is a problem because there's that if and what if they only seek the warrant harder because they know that there is some legal evidence. So a second claim here is replacing the exclusion of evidence with fines would improve the deterrent nature of the exclusionary rule, such as deterring these holes from happening and deterring the things, because the police are protected by qualified immunity in lawsuits, but not for monetary. They're not directly protected from, saying, a fine or like a payduct or something for committing illegal activity. And the illegal evidence used is better to be used in the justice system than left behind if justice is going to be held up as a value. Because, and the Supreme Court has actually said in the past, that unlike the Fourth Amendment, the exclusionary rule is not constitutionally compelled, but is simply an instrument to compel justice in what we consider as right. Also, that the Supreme Court has said that leaving out evidence offends the basic concepts of the criminal justice system.